Wow. I once covered a speech by Bobby Kennedy when he was senator, and he got this effusive introduction, and which prompted him to tell the joke about the grandmother who was wheeling her grandchild through the park. I know about this now since I'm a grandfather 6 times. And a friend came up and said, "What a beautiful baby." And the grandmother said, "That's nothing. You should see her picture." So if you're disappointed, there'll be refunds as you leave. You know. This beard actually gets me misidentified lots of ways. In the Soviet Union, and some dissident thought I was a KGB agent. In Afghanistan, a guy said, "You could be a mullah." In Maine, where I spend the summers, tourists thought I was a lobsterman, and they wanted their picture taken with me. I applied for a frequent flyer card at the airport once, and I got it in the mail. It said Rabbi David K. Shipler. I still have that up on my wall. You know, Lisa, to supplement what your father said, my favorite article of the Soviet Constitution was the one protecting the privacy of mail and telephone communications. And I remember a Soviet dissident telling me once he was called in by the KGB for interrogation after they'd searched his apartment. He started citing the Constitution, and the KGB agent said, "Please, we're having a serious conversation." Because after all, here too, the Constitution is more than a document, isn't it? It's a culture. Philip Booth, the poet who used to sail in Maine, where I do it in the summers, writing about the ocean and the ledges, had this great line. He said, "The chart is not the sea." And so the Constitution and the Bill of Rights are not the culture. It takes the ACLU and other soldiers, as Judge Lewis said, to keep that culture alive. You know, I spent about 4 weeks with the federal public defender in Washington, D.C., A.J. Kramer, you probably know, wonderful guy who said, "Yeah, come, I'll give you an office. You can go to court, look at the files, spend all the time you want here." And a lot of the federal cases in D.C. are street crimes because of the way D.C. is, not being a state. And I learned a tremendous amount, came out with the feeling that if I ever got charged with a crime in D.C., I'd like to be indigent so I could have these people defending me, because they were really good, really, really good. And I came to understand that they were defending not just individual clients, but the constitutional system, of course. When I told people I was working on a book on civil liberties, I would get these cracks, these wisecracks. "Oh, I remember them. Oh, you're doing a history." I was at a lunch with some retired generals and retired ambassadors and maybe a couple of ex-CIA types, and they asked me what I was doing, and I told them. And one said, "Oh, it'll be a short book." Another said, "Oh, you'll be a pamphleteer." Well, it didn't turn out to be a short book. It's 2 books. And of course, I'm not a lawyer. It will become very apparent if it all hasn't already. But I am a citizen, and I came to think that as a citizen, I had to act sort of the way the owner of a car ought to act. I ought to know something about an internal combustion engine and wheel bearings and how brakes work, and especially brakes, which have not worked well since 9/11. And I think that the law is too important to be left to the lawyers, and it's more accessible to ordinary laymen than most ordinary laymen understand. I think it's more accessible to journalists than they understand. I don't think there's enough law in stories about the law. I don't think that there's enough constitution in those stories. When they write about surveillance, for example, and searches, the words Fourth Amendment are rarely there. Notice, it's quite interesting. So in this time after 9/11, I began to think that I really needed to do something to continue my education about my own country. So what I'd like to concentrate on this evening is not just the rights as ends in themselves, as we often think of them as moral, as legal. They don't have to be explained and justified. After all, the Bill of Rights does not say that we have these rights because, and we talk about them in these terms quite regularly, but there are practical aspects also. And not just the question of government intruding on rights and acquiring to itself weapons that can be used in abuse against political dissidents, against minorities, but also another practical dimension that's not talked about much, but which I came to see in my own way. And perhaps people will disagree with me about this, but here's kind of what I came to think about all of this. That the framers left us an ingenious legacy of rights that actually maximize both liberty and security simultaneously. That liberty and security are not in a zero-sum game, as they've often been portrayed, especially in the post-9/11 era, but that in fact they complement one another in the observance of these rights. And I go back to something that I was told in Moscow, not when I was there as a regular correspondent, but when I went back to do some additional stories for the New Yorker in the Gorbachev era. I met a professor of criminal law who had been elected to the parliament during the brief time of Soviet democratization before the Soviet Union collapsed. He had been in the United Kingdom and the United States observing jury trials. He was quite impressed by how ordinary citizens could rise to fulfill the awesome responsibilities of being jurors. And he told me that in this era when the judicial system was beginning to show some independence, police were having a tough time making cases because they had never had to investigate crime very thoroughly before. They hadn't had to submit their evidence to testing. There was really not the kind of adversarial, there was an adversarial proceeding, but it wasn't robust as ours is. And so the police, as criminal investigators, were really starting from scratch. They'd become quite lazy. Their investigations were not tested by any restrictions of rights. And that kind of echoed in my mind as I went about my own research. And I began to understand that, in fact, the accuracy of the criminal justice system, and I would say the efficiency of the intelligence gathering system, are both enhanced by observing the rights. They force investigators, both on the criminal side and the intelligence side, to hone their investigations, to subject their observations and their efforts to certain adversarial challenges and criteria that force on them a certain precision that they do not have if they ignore these restrictions. I think the best example of the accuracy that's produced by observing the rights is the Fifth Amendment's guarantee of the right against self-incrimination. I'll give you a case that I came up with talking to a public defender out in California. This guy named Antonio Ramirez was shot 7 times in Oakland, and several months later, a 16-year-old kid named Felix was arrested on a tip. He was put in an interrogation room for hours. He asked for his mother. She was actually sitting outside, but was not allowed in. The police told him to draw a diagram of the scene. He did, but it was all wrong. He left out an alley, for example, that was there. And so they kind of fed him that information. He had the wrong direction of flight, as testified to by some eyewitnesses. They asked him about the gun. Where's the gun? Well, he said he didn't have a gun. And one of the cops really got close to him and started shouting at him until the kid finally said, well, okay, the gun is at my grandfather's. Well, both his grandfathers were dead. So he kind of cleverly inserted this absolutely false piece of information. And ultimately, he got really scared, and he was it was implied that he could go home if he just told them what he'd done. And so he confessed. He got to court. The charge sheet was presented. He looked at the charge sheet, and he saw the date of the murder, and he said to his lawyer, I was locked up in juvenile hall that day. You can't get a more perfect alibi. So the charges were dropped. As a result, the defense bar in Oakland pressed the police department to record all interrogations there from beginning to end, which they do now, apparently. That's not a panacea, by the way. If you ask defense attorneys, they'll tell you that if the jury sees that confession recorded, even if the preceding hours and hours of subtle coercion can be viewed, the confession can have a tremendous impact. The point here is that there are false confessions. We know that from the Innocence Project. I just checked with them, and of the 312 reversals of convictions based on DNA evidence, 25% involved false confessions. Knowing that only a fraction of cases involve DNA evidence, we can extrapolate and say with some confidence, I think, that there is a vast landscape of injustice because of false confessions. Eyewitness misidentification, which has received a lot of attention lately, is a larger factor in all conviction reversals. 73% of exoneration cases involve misidentification by an eyewitness. But if you take the subset of homicide convictions, false confessions actually are involved in 62% of the 104 reversed homicide convictions. So that is a huge problem. Now, of course, you know, it also means that the perpetrator is still on the street. Not just that the wrong guy is in jail, but that the right guy is out there continuing to do crime. This happened in the Central Park jogger case. You may remember in 1989, a young woman named Tricia Melly, who later identified herself, was raped and terribly beaten. 5 young men were arrested, separated from one another, interrogated, lied to by the police. One was told a fingerprint had been found on her clothes, not true. All their accounts differed from one another. Nothing coincided or overlapped. They gave the wrong location for the crime, 7 or 8 blocks away from the actual location. They gave the wrong time. There was no forensic evidence. Later, hairs found on one youth couldn't be matched to Melly, and semen on her sock was not a match. They were convicted because of their confessions and were given 5 to 15 years. Years later, a prisoner named Matthias Reyes confessed to that crime, and he knew all the details. And in fact, by that time, there was DNA, and so they did match forensically. And it turned out that this guy, while these 5 guys were interrogated and being sort of coerced into confessions, this guy Reyes was still out there, and during that summer, he raped 4 more women and murdered one of them. How does that make us safer? This is what I mean about that there's no zero-sum game here between liberty and security. If we observe the rights and force our law enforcement to do it, we'll be better off, we'll be more secure. It's easy to blame rogue cops, but it's the systemic problem, actually. Because the law and case law permit police to do a lot of things that really push the envelope on the Fifth Amendment. Remember also, as all of you know, but a lot of people don't think about this, that the Miranda warning involved a guilty man, in fact, Ernesto Miranda, who was no model citizen. Yet a model police practice bears his name. From the 8th grade, Ernesto Miranda had a record. The crime he was accused of was kidnapping and raping a mentally defective 18-year-old woman. The Phoenix police, why is so much of this stuff in Arizona? The Phoenix police told him falsely that he had been identified. They promised to drop a robbery charge. They did not advise him of his right to silence or an attorney, which was not required at that time. So he was convicted based on his confession. So in 1966, as you know, the Supreme Court ruled, only 5-4, by the way, that he should have been advised of his right to silence and to an attorney. So they retried him. This time, his common law wife testified, no spousal privilege there, they weren't formally married, that he had admitted the crime to her and he was convicted again. So we have to keep reminding ourselves and everyone else who cares about the constitutional system that the rights are really defended by people who are not always great people. You know, they're people who may have done the crime. Maybe the search was illegal, but it did turn up evidence, but it was illegal. I mean, the constitutional rights are not divisible. What applies to Miranda applies to me and you and everyone else. But the police are really given a lot of latitude in the interrogation room. You know, there's a small industry that's grown up to train police interrogators. And it's a very clever, if you go online, you can find Reed Associates, R-E-E-D. You'll see their website. They have all kinds of manuals and tips. It's really quite interesting to read them because they're very scrupulous, I think, about staying within the boundaries of the case law and advising police interrogators how to get a confession without violating the Fifth Amendment as defined by the courts. So, for example, they'll suggest that the police Mirandize the person in custody casually, not make it a big deal and stop the clock, you know, and say, but sort of say, oh, you know, this is one sort of technical thing we have to do. Here, just sign this and then we'll get on with it. The police can lie about evidence. So a police officer can say, well, here's a lab report that shows, your blood matched the blood on the victim. As long as the officer doesn't actually create a false lab report, judges don't like to risk false evidence getting in, but they can pretend to have it, can wave a DVD and say, this video shows you going into the store, can wave a fingerprint card and say, your fingerprints match the fingerprints on the doorknob or on the gun. So your friend, told you, well, we have a witness who saw you, and so forth. They can create an environment in which the person is surrounded by evidence that may very well not be accurate. They can minimize, they're advised, actually, trained to minimize responsibility. So, it wasn't your idea, was it? Wasn't it your pal's idea? Or you were probably angry. I mean, it was probably justified. You were maybe, as long as you have to be careful, though, these tips say not to give the defendant a defense, like self-defense or something like that. You don't want to tell him how he can defend himself, but you want to create an atmosphere in which he feels less guilty for what he's done and less responsible. And then there can be subtle suggestions of leniency as long as there's no quid pro quo. Now, this is very effective, particularly on children who basically just want to go home and will probably or be reunited with a parent and can be led to think that if they just tell the story the way the police want it told, they'll be allowed to leave. It's effective also with mentally retarded people or marginally or borderline retarded. It can also happen, though, with mentally healthy adults who can give false confessions. So why would people give a false confession? There's something called the memory distrust syndrome, which a clever interrogator can activate in people, especially people who've been traumatized. There was a case of a 17-year-old who woke up one morning to see both his parents having been slashed in the house, and he was arrested, convicted, confessed, convicted, and finally got out, I think, a long time, 15, 20 years later. But the whole syndrome was a very interesting one because the police officer interrogating him lied to him and said his father was still alive when he was taken to the hospital. The police officer went into the next room. There were two phones in the room where the defendant could hear. He picked up one phone and dialed the extension. And the extension rang. The same officer picked it up and pretended to be having a conversation with an officer at the hospital. Wow, really? He said that? Oh, gee. Hung up, went back and said, Marty, your father regained consciousness and said that you did it. So this kid was completely disoriented, and he exhibited what is called an internalized false confession. That is, he said, well, could I have blacked out? Or, well, maybe there was some other part of your personality that did this and you really weren't aware of it. So this internalized false confession is not as uncommon as we might think. There's an experiment done with college students where they were told to sit at a computer keyboard and type out a paragraph or something, but don't hit that key because the computer will crash. So the person doing the experiment made it seem as if the computer crashed, and then the students took the blame. They said, "Oh, I guess we did it," and they even described how they had hit that forbidden key even though they hadn't. So, and in a police custody situation, of course, where your faculties are not operating at, high level, it's easier than you may think to create that kind of syndrome and pattern. So that's the Fifth Amendment. The Fourth Amendment is a little less easy to give you a persuasive argument about, but I'll do my best anyway. First of all, on the idea of security. Let's remember the language of the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Secure. Security from the authorities. Security from government. Now, I'm going to talk a little bit about what I think that means in the current era that we're sitting in right now. But let me just tell you first what I've learned from former intelligence people with whom I've spoken about the vast surveillance that's taking place. Many of them say there's too much information coming in. They cannot go through it. At the end of one guy said to me, all the computer systems in the world are fine, but at the end of the process, you need a human being to look at it and decide what it means and what action to take, if any. And what they say is, we don't have the capacity to do that. We cannot connect the dots. There's just too much stuff coming in. And we've seen that in a few cases. Umar Farouk Abdul Muttalib, the underwear bomber who tried to blow up a plane over Detroit, was radicalized to the point where his father went to a U.S. embassy to report him, and that never got put through the system. His visa wasn't revoked. He didn't get extra screening when he got on the plane. The head of D.C.'s intelligence said to the police, at a police department in Washington, D.C., the head of intelligence there said to me, he said, "I get so many emails, I can't read them." I said, "How do you decide which ones to read?" He said, "Well, I can't talk about that." I said, "Well, what's your reaction?" He said, "Oh my God, turn it off." Thomas Drake, who was a very high official in the National Security Agency and became a whistleblower, said that there are just huge amounts of unread stuff. He said after 9/11, he was in a position to advocate that a program called Thin Thread, which had certain interesting capabilities to actually look at information in real time, be activated and aimed at a database of communications. And he had to fight for it, but they did it. And what they came up with was what he called actionable intelligence on some of the 19 hijackers that could have prevented the attacks. And this was never publicized, he said, and the 9/11 Commission never looked into it. The NSA basically got a free pass on that investigation. And the NSA suppressed it and didn't put Thin Thread in the trash bin, partly because they didn't want their reputation damaged. There was devastation, he said, in the agency after 9/11. Tremendous, distress that they had missed something. And when they found out that they really had missed something, that they actually had, but had too much stuff, this was not before 9/11, now you can imagine what it's like now, it was just a public relations nightmare. I mean, I love the ACLU's metaphor. If you're looking for a needle in a haystack, you don't have a better chance of finding it if you increase the size of the haystack. So I think that, in fact, you could make a very good case. We don't know enough. We don't have enough information to make the case, but if we ever get a decent investigation of what's been going on, I think it will probably show that this vast surveillance, while very useful in certain situations, I mean, it's, we're in gray areas here, but that a lot of it is actually counterproductive, that it doesn't force people to filter out first what they're looking for and try to hone in more precisely on targets. Justice Louis Brandeis talked about the right to be let alone. It's a nice phrase. He wrote that in a dissent in the 1928 decision permitting warrantless wiretapping of phones, Olmsted, on the argument that, well, the signals leave the house, they go out into the wires, which is a great illustration of how far behind our technological situation the courts always are. So it wasn't until 1967 in Katz that the Supreme Court required warrants on telephone conversations and devised a new test to determine the Fourth Amendment's jurisdiction. Quote, first, that a person have exhibited an actual subjective expectation of privacy, and second, that the expectation be one that society is prepared to recognize as reasonable. This reasonable expectation of privacy is a critical ingredient of Fourth Amendment jurisprudence, I think, especially in a digital age. The courts think that when we give information away, we no longer, to a third party, we no longer have a reasonable expectation of privacy. Write a check, our phone calls, our email contacts, not the content, but the metadata that we've heard so much about since the Snowden revelations that's being collected. And it seems to me that we're at the cusp of a reassessment of this. And I have a little bit of hope about the courts possibly looking hard again at the reasonable expectation of privacy in a digital age where, let's face it, you can't live without giving your information away digitally all over the place all the time. And I have a little bit of hope because of the GPS decision a couple of years ago. You remember that the court unanimously ruled that the police have to have a warrant to attach a GPS tracking device to a vehicle. And there were lots of opinions and there were different rationales. Some of them that it was a physical search because you have to physically actually attach the device. But some of them also picked up what the DC Circuit had said about, I guess you could sum it up that quantity creates quality. That is, if you track someone 24/7 for 4 weeks, which was the case with this alleged drug dealer, you know much more about him than an individual police officer following him in the public streets. I mean, you have no expectation of privacy on the public street, but you know much more. You know what church he goes to, or synagogue, or mosque. You know whether he's going to the doctor. You know whether he's having an extramarital affair. You know all about him. And that is much more intrusive than he has any reasonable expectation to expect. And I think it was Sotomayor in her concurring opinion who raised the issue of re-examining the question of a reasonable expectation of privacy. So I'd like to think that we're getting there, that the courts, and we have now mixed opinions in the lower courts about cell phone location tracking. So, there is perhaps beginning to be some recognition of the fact that in a digital age, these parameters have to be redefined or at least clarified. In my mind, when I give information to my stockbroker, I don't think I'm giving it to the FBI. The right to be let alone has intrinsic worth. It's difficult to define and explain and justify in a policy debate, especially today in a time of terrorism. Its virtue, I think, cannot be measured by pragmatic rationales, even though I've given you a couple. Its purpose cannot be calculated with any precision. Privacy is like a poem, a painting, a piece of music. It is precious in itself. Government snooping destroys the inherent poetry of privacy, leaving in its absence the artless potential for oppression. At the least, if the collected information is merely filed away for safekeeping, a weapon is placed in the hands of the state. If it is utilized, acute consequences may damage personal lives. Justice Robert Jackson said it very well. The Fourth Amendment protections are not mere second-class rights, but belong in the catalog of indispensable freedoms. Among deprivations of rights, none is so effective in cowing a population, crushing the spirit of the individual, and putting terror in every heart. Uncontrolled search and seizure is one of the first and most effective weapons in the arsenal of every arbitrary government. Intrusions on the Fourth Amendment have kind of waxed and waned throughout the history of the Republic. Severe limitations on the warrant requirement predated 9/11. They really went rampant during the war on drugs. Federal District Judge Paul Friedman, who's a very respected judge in DC, does a lot of gun and drug trials, said to me, when I was talking to him about this, I don't think there's much left of the Fourth Amendment in criminal law. That's quite a statement from a federal district judge. I went out with a police unit in DC, a couple of police units. One was a drug unit, undercover narcotics unit. The other was a gun unit. They called it the power shift. Started late at night, went out on the street, did a lot of frisks of pedestrians, similar to what's been publicized in New York City, pushing the boundaries of the Fourth Amendment quite a bit, I'd say. And what happened, they traveled in uniform in marked cars because they want to see the reactions of people. I went to a training course the police academy had where they were taught how to tell if somebody has a gun. So you got 4 guys standing on a street corner, the police come up, 3 guys look at the 4th. People have guns, they tend to pat their waistbands again and again. If they run asymmetrically. Their arms are asymmetrical because if they run faster, they're holding the gun. And then if they've thrown the gun, then they become asymmetrical again. Look where they started to do that. If maybe a coat is hanging one side or another. Anyway, all these tips that police use to try to figure this out. Well, what would happen when the power shift would pull up to a street corner on a hot summer night, a bunch of guys standing around in Southeast DC, that these guys would just, without the cops saying a word, these guys would just pull up their T-shirts to show that they didn't have guns. It's like going through airport security, taking off your shoes. Same thing, except they're in their own neighborhood, in front of their own houses. Now, if this happened in white neighborhoods or on college campuses, can you imagine the uproar? This is a black neighborhood. People are used to it. They don't like it. You could see by the looks on their faces, but they're accustomed to it. The other thing that happened was very often people gave consent. And I would ask to be searched, to be patted down, to have their vehicle searched. And I asked some people, did you give consent? And they'd look at me with surprise. But what do you mean? I said, well, you don't have to give consent, to the police. They asked you if they could search. You mean we could say no? Well, I ain't got nothing to hide. Well, what would happen if I said no? They'd search anyway. Then they'd think I really did have something to hide. So that was the sort of pattern. There are rules, of course, about searching vehicles. If you see evidence of a crime in plain sight, a little bag of crack, the handle of a gun, you can search without permission. But, the warrant requirements are much looser on vehicles since the evidence can be driven away, and that's all justifiable. But basically what you have here is it reminded me a little bit of like a football game where the players, commit fouls and they hope the ref isn't looking. They might get away with it. But the only time that they're challenged is if they make an arrest and the case comes to court. I mean, I counted, the vast majority of people who were searched either as pedestrians or as drivers had nothing. And unless they choose to sue the police, good luck with that, winning that one, or finding a lawyer to take it on contingency, there's no record of it, and there's no challenge to it, because no charge is made, and therefore there's no motion to suppress the evidence and so forth. So that's what we have in that area on the street. So we have a whole spectrum of Fourth Amendment intrusion, from the NSA surveillance at one end all the way over to the street on the other. And it's most open and accountable on the street, because if there is a charge, then of course it can be challenged. And the federal public defenders in DC, I would guess, based on my weeks with them, I would guess probably most of the motions that they filed on behalf of their clients had to do with illegal searches, or they felt were illegal. They were trying to get the evidence suppressed without much success, by the way, although sometimes they did. Now, one of the people say, well, I don't have nothing to hide, right? So why should I care? I just want to remind you about the case of Brandon Mayfield, the lawyer in Portland, Oregon, whose fingerprint was matched by the FBI erroneously to a fingerprint on a plastic bag of detonators found near the Madrid train bombings. And when the Madrid National Police sent that fingerprint to Interpol and it was distributed, the FBI called examiners in on a weekend, told them what the case was about. They used their computer system and came up with, I think, 20 or 30 possible matches. An examiner picked Mayfield's without knowing he was a convert to Islam, by the way. I think that was a falsehood that people said, well, it's because he was a Muslim that they picked his fingerprint. Yeah, it didn't work that way. The card didn't have his religion on it just had his name. But then the FBI office in Portland, of course, figured out that he was a Muslim and that he had represented one of the Portland Seven, but it was in a family law case. It was about custody. It was the guy was about to go off to jail, and Mayfield was working for him on that issue. So what happened was that the FBI used the Foreign Intelligence Surveillance Act to do sneak and peek searches, and Mayfield kind of discovered this, sort of began to get a kind of funny feeling that somebody had been in his house, and for various reasons, he saw, for example, their Muslim family, and they saw they had a new carpet. First of all, one of the locks on the front door was locked. They never lock it. They saw footprints on the rug. They saw louvers bent open in his son's room above the son's eye level. They kind of began to wonder. Somebody had been in the house. They even called the police because there had been some arson in the neighborhood. The police said, well, is anything missing? And he said, well, no, it doesn't seem to be anything missing. Well, would you like us to come and really look it over? And he said, well, let's see if it happens again. It happened again. And what happened was that the FBI, did copies of his hard drives, in his law office too, by the way, and began to fit the evidence to the theory of the crime. I think one of the most disturbing things about this story, aside from the search, warrantless search, it was I don't know what you call this, the corrupted intellectual mindset of the FBI agents. For example, they saw on a computer train schedules in Spain. Aha, well, it turned out it was his middle school daughter's assignment to plan a fantasy vacation. They saw on a notepad a phone number in Spain. Turned out it was the phone number of an exchange program they were thinking of sending one of their kids to. They discovered that neither Mayfield nor his wife had had a valid passport for a decade and had no record of traveling overseas. Now, what did they conclude from that? Gee, maybe we have the wrong guy? No. They concluded he must have traveled under an alias with false documents. The agent even swore in an affidavit for a regular search warrant that this was probable, with absolutely no evidence whatsoever. This is our FBI who's protecting our security. The FBI, when the Spanish National Police looked at Mayfield's print, they said it's not a match. The FBI said, oh, yes, it is. They said, no, it's not. FBI agents flew to Madrid more than once at our expense, trying to persuade the Spanish National Police that it was a match. Luckily, the Spanish police actually found the guy through a whole series of kind of coincidences, and so they discovered whose print it really was. Otherwise, Mayfield probably would have been, I'll bet he would have been convicted, actually, in the mood that existed at that time, 2004. Instead, he was released and settled for $2 million of our money. Now, how does violating the Fourth Amendment make us more secure? You know, Alexander Hamilton was disparaged earlier by EJ, but I would like to quote something approvingly from him. He wrote in the Federalist Papers about nations that face national security problems. And he said, even nations most attached to liberty, he was speaking of nations, even most attached to liberty, quote, to be more safe, they at length become willing to run the risk of being less free. The risk of being less free. So, it's true, maybe we're not self-correcting, as Judge Lewis said. Maybe Peter Baker is wrong. Some people like to say that it's a pendulum that swings back and forth. We are now in what I count the 6th era of major deviation from our constitutional liberties in the name of national security. You can count them differently, but I think it's fair to say that the post-9/11 era is the 6th era. Every one of these deviations we now look back on with shame. I'm hoping that someday that will be the case. But if the pendulum swings, we all have to give it a hard push. Thank you very much.